Hello, everyone, and welcome to today's Ed Leaders Network live event, Bullying, Litigation Protection, Prevention, and Response Strategies with Judy Bruner and Dennis Lewis. My name is Arlen Peebles with the Illinois Principals Association, and I'd like to quickly go over the GoToWebinar control panel so you can enjoy the full extent of the session today. On the right-hand side of your screen, you will see a strip called the GoToWebinar control panel, and there are a couple of items I want to bring your attention to. The first being the audio portion. Most of you are logged in listening through your computer speakers, and if you can hear my voice and it sounds good, that is the way to remain in the session. However, if you do have trouble with audio and it drops out, you can switch over to a telephone if you've got one nearby and reconnect to the audio in that way. There is also a questions box there where you can type in your questions or comments as you think of them, and then we'll go over those questions at the end around 11 o'clock today. When we finish up, we will look at those questions and answer them. I have also posted a link to download the PowerPoint in a PDF format. If you did not get my email yesterday or this morning from that, I posted that into chat. There should be a link for you to click on and download. All right, that is all I need to introduce to you this morning. I'd like to now welcome to the stage Judy Bruner and Dennis Lewis. Good morning, guys. How are you?
Good morning. Thank you, Arlen.
Yeah, we're doing very well.
Well, we're broadcasting today from Columbia, Missouri, and this is really a very neat way of delivering training, one that we really enjoy. And we'd like to welcome all of our attendees from not only Illinois, but we understand we have from Missouri and Indiana and Minnesota as well. So welcome to everybody. Just a little brief introduction of what you're going to hear today, and then we'll get right into the material. This is a fairly narrowly focused aspect of the issue of bullying and harassment, but one that is taking on added importance as we see litigation continuing to increase across the country on this topic, especially east of the Mississippi River, though I will tell you it seems to be progressing across the country rather rapidly. And so this is a fairly new PowerPoint program and training material that we've developed, very specific to helping school districts and individual schools and individual school staff hopefully keep from being litigated on this topic. But if you find yourselves in those shoes, you'll stand a better chance of coming out on the winning end, having set through this particular program. So, Judy, any comments before we get started here?
No. I will tell you, we will try to make all of our remarks very practical. I'm a career educator, having served as a school principal for 17 years and a teacher beyond that. And then Dennis is a former director of school policing in the Springfield, Missouri School District. So we've kind of combined our expertise here, him from the law enforcement side, me from the school side. And what we've put together this morning, we hope you'll see, will be just some very practical suggestions. Most of them will not cost you any money, may have you rethink a few things, but if you'll take the time to kind of go through it, and we'll throw some spaghetti at the wall, and then you'll have to decide of all the strands thrown, which ones will stick for you and the folks in your district. So let's get right into it, Dennis.
Okay. I want to spend just a moment talking about liability, and anyone that's attended or had the opportunity to sit through a school law course obviously has had a dose of liability. But one of the things that we are seeing in a number of these cases across the country is clearly the emphasis on the plaintiff's part of tying the requirement of the duty to act and the duty to provide a safe environment to the various aspects of the bullying and harassment. And so keeping this definition of liability in mind, what we've highlighted and read for you, kind of remembering that as we go through some of the material today, will kind of help you understand a little better where this is all coming from.
Okay. Well, one of the things that you may or may not be aware of is that there are some law firms now that are actually going out and soliciting business, in other words, advertising on this issue. We'll draw your attention to that arrow. It says your child may be entitled to compensation if he or she has been harmed mentally, physically, emotionally as a result of bullying. Well, we know from the statistical information gathered on this topic that a lot of kids, and a lot of you in the audience will have been bullied or harassed at some point during your K-12 experience. And so most of us can look back on at least a few times in our lives where somebody hurt our feelings, somebody did something that was harmful to us, and if you are so inclined, especially in this economic recession, it may look fairly appealing to you to go try to make your case. We find that, at least in the cases where we're helping some districts defend themselves, that what has happened in those instances is one or two law firms file the initial suit, then that becomes public record, and the next thing you know, there's almost this pile-on effect of other people stepping forward and saying, you know, my child went to that school and this is what happened, and so the attorneys are very willing to go ahead and file lawsuits, just one right after another. Some of these cases get settled before they ever go to a jury or in front of a judge. And, you know, I don't know. I mean, you never really know what's in somebody's head, but it wouldn't totally surprise me. But what some people aren't hoping, that's exactly what happens, because it's expensive to try to defend yourself against this kind of stuff. You know, they're paying expert witnesses, they're paying legal fees. School personnel are wrapping up a lot of time and emotional energy into gathering information, and so sometimes it's just easier to settle out of court. And I think to some degree folks are hoping that's exactly what happens. But do be advised that there are law firms out there running TV ads as well as in other locations advertising, you know, if your child's been bullied at school, you may be entitled to compensation, please call us. What are plaintiffs alleging? Well, there are 5 things kind of have stood out to Dennis and to me as we've looked at some of these cases. First of all, they're accusing us of failure to provide and maintain a safe environment. And you know very well all the things that you're doing within your school and within your community to provide for a safe environment. We would recommend that you develop what we call a school safety portfolio, where you actually list and advertise all the things that you're doing in the name of school safety. And I would bet any one of you, if given enough time, could come up with at least 100 things that you're doing in your school or your district to maintain safety. So take the time to put that together. They accuse us of failing to stop the bullying. This is a real tricky issue, folks, because Dennis and I try to make it very clear when we're involved in one of these lawsuits that it's unrealistic for parents or students to believe that those of us at the school level or in a school district can stop all the bullying from occurring. Now, we have obligation to investigate, we have obligation to put plans in place, we have obligation to listen carefully to what people are saying, but one of the things that we really think parents and kids need to be educated is the fact that, you know, we really can't stop all of it. So to expect that would be unrealistic. They accuse us of failing to discipline the bully. You and I, we all know how people jump to that conclusion because of FERPA. We can't explain exactly what we've done, but do know that is a source of irritation to folks when we can't give them specific information. They accuse us of failing to follow policy and law, so it would be our recommendation that all of your employees have a copy of the bullying prevention policy that your district has in place, and that they sign off that they received it, they understand it, and had an opportunity to ask questions. Because you really do want them to line up behind what the policy expectations are. And then they accuse us of failing to prevent an injury, which was physical and or emotional. And that's easier said than done too. But we thought you might be interested in the kinds of things that are bubbling up in terms of these lawsuits, what they're actually accusing school personnel of doing.
Some of you may be familiar with this case. This is Davis versus Monroe County Board of Ed. It is the only U.S. Supreme Court case out there right now that addresses very specifically the issue of bullying. And a couple of quick things on this case that you'll find of interest. It's a 1999 case, contains no cyber aspect. It was a sexual harassment case, student on student, on campus, more in the traditional sense of what we typically think of bullying. It was a case that wound its way through the courts, ended up in the 11th Circuit. The 11th Circuit, in their ruling, which supported the defendants, in other words, supported the school district in the case, ruled basically on not the merits of the case, but ruled on the issue of the immunity that the district had from litigation as a government entity. As all of you are aware, there's a high level of immunity provided to government entities, on the topic of litigation. This case was appealed to the U.S. Supreme Court by the plaintiffs, and on a 5-4 decision, which wouldn't probably surprise anybody watching court decisions in the last decade, the court ruled on behalf of the plaintiffs ruled against the school district, remanded the case back to the lower court for a further hearing. And what the court said in essence was that there was, while they didn't disagree that the immunity piece was there, they simply said that there were 4 aspects or 4 circumstances that could be present in any case that might trump immunity. What they indicated were these 4 were: the school had knowledge of the harassment, that the school could be deliberately indifferent to the harassment. There was any evidence that showed either the knowledge or the deliberate indifference that might trump the immunity defense. If the school exercised control over the harasser and the victim and in the context of which the harassment occurs, which is kind of good news, bad news. It obviously no cyber in the case, and what we know about the cyber piece is that we typically do not see that occurring at school. We typically get the fallout from what's occurred off campus. So that's kind of good news on that. But again, if we exercise control over the harasser and victim and the context, that may trump immunity. And lastly, that the harassment was so severe, pervasive, and objectively offensive that it denied the victim access to those educational opportunities usually provided either in state constitutions or by law. And I will tell you, in many of these cases, you will see victims or plaintiffs whose parents have pulled them out of school, transferred them out, or providing homeschooling. And what they're alleging then is that they did so because of the condition or the climate there at the school that caused them to be victimized.
We wanted to bring to your attention a couple of cases, and you've got a lot of stuff there on your screen and on your PowerPoint if you've downloaded it. But there are some things about this particular case that we think has merit. This is a case where some kids were on a speech and debate trip. Those are usually overnight trips. They lured one of the students into a hotel room where they wrapped him in plastic duct tape, took photographs, displayed those photographs later. 4 months after the incident, the parents of the victim became aware and filed a lawsuit against the school, the teacher, and, interestingly, the students who participated in the act or left and failed to tell an adult. You'll actually see on that second bullet up at the top, one student fled the room but did not tell an adult and was later litigated on that fact. So one of the things that we would really recommend be a part of your parent and student education component is that parents and students understand that not only if you participate in these activities might you find yourself being investigated by law enforcement because it may be a law violation, but the fact of the matter is the victim can come back and sue the students and in their behalf the parents, and usually they're going after the homeowner's policy, whatever's in there in terms of liability. And so parents not only, if they downplay this at all, that their child was taking part in this activity, they may be facing legal repercussions as well as financial repercussions. And folks, we think that the public really needs to understand that. Because this award was fairly significant, and a lot of it did come from the student lawsuits to the other students and their parents. This is a case that we think, this is out of Kansas, that we think we should always highlight a little bit. It really comes down to some real inappropriate things in terms of language and this kind of civil conversation that should be in the school building. This young man claimed in his lawsuit that he had been called a lot of names over the years, particularly beginning in 7th grade. He was the recipient of gay bashing, and the jury awarded $250,000 to this young man. He said, I had to drop out of school. I was so uncomfortable. I was miserable. And so we bring this to your attention because sometimes some of the language that, quite frankly, gets overlooked in a school because for some kids it's just part of their vernacular. We would just caution you not to overlook it. I will tell you, folks, you really can't defend yourself against it if the allegation gets made and if it can be substantiated that it occurred and you did nothing. So please educate your, if you're a principal, educate your faculty. If you're a teacher, keep your administrator and your counselors in the loop when you hear this kind of stuff. There's just are certain words that should not be allowed in our civil discourse at school, and some of those words on your screen are part of that. So be real cautious with it.
And I would just add to that a number of the suits that are working their way through the courts across the country, I would say a good portion of them will have some aspect of gay bashing in the allegation. So this, is one thing we really wanted to alert you to. Some staff may not feel comfortable addressing this kind of language for various reasons. But from a leadership position, you're going to have to emphasize to staff that this is an absolute